Now, as those of us who run our own businesses know, we ignore the law and the accounts at our peril. Now, sure, when we did first start out, we may have taken some risks to get started. We're not recommending that, but let's face it, most of us did it. So just to help make sure that you are covered and you have everything in place that you need to either get started, pivot to something different, or actually just carry on operating successfully as yours has been. We have got two experts here for you today. So the first of whom may be known to some of you who have watched other industry presentations. Welcome to Jeff Ment of Ment Law Group. Jeff is a foremost expert in our industry. Admitted to the Connecticut and New York bars, Jeff has over 26 years of experience representing travel companies and hospitality groups. A regular speaker at large travel industry events, Jeff is incredibly knowledgeable about the legal issues facing our industry and tour operators. So thank you for joining us, Jeff. Going to be handing over to Jeff in just a second. Secondly, delighted to have Alex Jake, who is the graduate of Fresno State with a Bachelor of Science in Business Administration Accountancy. Alex began his accounting career at Deloitte, where he gained valuable experience working on tax compliance and consulting projects for privately held companies and their owners. Now, I know we'll have quite a few of those listening in today. So we're going to kick off with the law, with the legal side, because frankly, that does underpin everything that we do. Now, Jeff recently gave a fantastic 75-minute long presentation at another day, speaking at a different event, and I've challenged him to deliver that in less than 20 minutes. Now please don't stress about making notes and keeping up with everything if you're watching. We are recording this and we will circulate it hopefully sometime next week. So don't stress too much if you miss anything. The chat's open. Feel free to ask questions, post some comments, get some chat going. And that's it. So Jeff, thank you very much, and over to you.
All right. Hey, thank you very much for having me. I'm here in Connecticut. It's a rainy, gray day, but I am happy to share with you my thoughts on the travel world. I feel your pain. It's a tough place we're in right now. I am the son of a travel agent mom and a judge dad. So I find myself perfectly well situated talking to travel people about the law. I've been a travel agent, a tour guide, and I've worked for 2 airlines. And so I feel pretty comfortable talking to travel people. My clients range from the smallest to the largest around the world. And so I'm good for kind of everything from the beginning to the end of a travel company. The challenge today is to get a lot of information across to you. I'm going to do the very best I can. If I go too fast, just drop me an email if you have a question about something. We are ready for the gates to open. We are ready for the takeoff to begin so that we can start taking people around, selling travel, and sharing our experiences with everyone. That's what we're really all about. The law, however, requires us to be sort of circumspect and to take care of our business and take care of our assets and take care of ourselves. That's why Alex is going to share such good information about business formation. That's why insurance speakers will tell you more about protecting yourself. But all of us would encourage you to be mindful of the fine print and to think about ways to protect your business. Your guests are your friends until they're not. And then they are the litigants against you or the people making claims against you. And it's very discouraging to think of it that way. But I share with you the thoughts of nearly 30 years of doing this, that those are the people who make the claims and bring the lawsuits. Waivers. Everyone knows what a waiver is. It's a way to have someone sign something to protect you from being sued or having a claim. It's a cute little cartoon there, but you really are looking for ways to be not responsible. Waivers are contracts. Waivers are contracts that protect you from responsibility for known or unknown risks. That's a key part of the waiver. If you limit it to just certain specific known things, you may be not having it be broad enough. And look, we all do different things in travel. We might be a multi-day operator. We might be a single experience operator. We might be taking people to 5 restaurants in our city. We might be doing a walking tour. All of us are in the same situation of having these exposures and risks. So waivers are something that you should strongly consider if you don't already have one. Waivers have to be drafted so that they are going to be effective and found to be valid. So you do have to give some consideration to the wording. You have to give some consideration to the state you're in. You have to think about what is going to be found to be valid or invalid depending on your location. So the waiver has to not violate state law or public policy. These are basic tenets of legal interpretation, and I'm just trying to bring the law to life so that we all can have a good understanding of what we're looking at. Again, known and unknown risks are important. There are a couple of states that don't allow waivers. So you can either not operate in those states, which might be difficult if that's where you live, or you can try to just be mindful about whether or not you want that law to be controlling. A lot are used to seeing language in a contract at the bottom that says the law of a certain state will be applicable. You don't have to have that in your waiver or your conditions. That's an option if you want to pick a certain state. If you're in a state like Virginia or Louisiana that don't allow waivers, well, by golly, don't pick that law to be applicable. So anyone that is coming on your tour can ordinarily bring a claim against you where they live or where you are. They are far more likely to do it where they live unless you limit it to where you are. If you're in Virginia or Louisiana, you definitely don't want to make that the controlling law. And those are just 2 examples. Those are the 2 examples in the United States of the states that don't allow waivers. So if you're in one of those 2 states, don't pick any law. Let the people bring a claim wherever they want to. The only thing you need to be really careful about with waivers is the bottom comment here. You never can waive your own gross negligence or intentional conduct. Obviously, that makes some sense. But the problem is if you put that in your waiver, you run the risk of invalidating the whole thing. So just go back, take a look at your waiver, make sure it passes sort of the test about what you're talking about, and trim it down so that it's protecting you against the known risks, and then having a catch-all phrase about and any unknown risk. We are now entering the world of whether waivers are going to be valid on COVID, and people are getting very nervous about them. All waivers need to be conspicuous. They need to clearly identify what the risks are and that people are waiving their claims by signing a waiver. Conspicuousness means setting it apart from other provisions, using a clear heading, requiring a separate acknowledgement, using capital letters, using words that say, read carefully, signing this document affects your legal rights. So when a court is analyzing the validity of a waiver, the very first thing the court is looking at is conspicuousness. So I think you're getting kind of a good idea about waivers. You definitely should have them. Waivers can include your own negligence. So some companies and some clients of mine only want to waive liability for other companies. So if you're taking someone to a restaurant or you're taking someone on a pub crawl, you clearly want to waive the negligence for those other companies. So you don't want to be sued for somebody else's negligence, but really you should also include your own negligence so that you can protect yourself from being the target of a claim. Okay, next topic, moving along quite quickly, keeping up with Adam's challenge. COVID litigation is happening. And so I have to sort of be mindful of the fact that we do need to get our industry moving again. And we do need to do it with some forethought, however, about what can happen. I've already had some of my clients run some trips in the past 3 weeks, and 2 of them have had COVID positive people afterwards. And so it's creating some angst and fear in terms of what we have to be thinking about. COVID litigation is everywhere around the country. I'm involved in several cases already. There are more than 48 pending class action lawsuits out there right now. The largest targets are, of course, what you would imagine, the airlines, the cruise lines. Tour operators are unfortunately in third place right now because we are often the target of a class's ire. Are DEOs going to find them facing class actions? Let's hope not. Let's really hope not. But to the extent that you are at all worried about a class action, you can have a class action waiver in your terms, in your conditions. I'm not going to talk much about that because I don't know how applicable it is to all of you. But if you have even the slightest concern that a group can band together and bring a class action, you can diffuse that by having a class action waiver in your terms and conditions. Here's a great quote from a consumer about why he got involved in litigation. And the reason he got involved in litigation against the tour company was really because communication has been vague. It's been passing the buck. It's been someone blaming someone else for the lack of refunds. I listened to Rick Steves' presentation, and I have clients just like him who gave all the money back. But I have clients unlike him who couldn't give all the money back because they didn't have enough money to give back because it had been passed on to downstream suppliers and vendors in other companies. So if you are still involved in any unraveling of the 2020 trips that couldn't happen, or if you are thinking ahead about how to avoid it, I want to share with you just a few examples of what this litigation is about. So these are all real cases. The names are removed to protect the guilty or the innocent. But here's a story where a student group tour was canceled due to COVID-19. But the tour operator said, hey, you canceled during the cancel penalty of 70%. So we're only going to give you back 30%. Of course, that led to an outpouring of complaints and people saying that's not fair. And the lawsuits claimed that the tour operator shouldn't be able to keep the money. The tour operator says, well, we were ready to go. We were ready to perform. We paid our vendors and we can't get our money back. The plaintiff is the person bringing the lawsuit. They say, that doesn't matter. We couldn't go. It's your fault. So to the extent that you're listening to me now and you're on the vendor side and you have tour operators asking you for money back, or if you're the tour operator and you're in a difficult box because you don't have the money, you can understand everyone's frustration in this example. Another example, a student tour group is scheduled to go in March. The school cancels the trip. The school then asks for the trip to be rescheduled. We've had so much fussing about rescheduling and credits. It can drive you crazy. But in this case, the tour operator rescheduled the trip. Then the school canceled the trip again. And then the school gave all the money back to the parents, even though the parents had paid the tour operator directly. And then the school came looking for the money back. Now, from a lawyer's perspective, that's really interesting because the contract wasn't even with the school to begin with. So we've been going back and forth about how that case can find a successful conclusion. Again, when groups are canceling, the most common theme that we are hearing is that the travel company, whether it's a DEO, a vendor, a tour operator, the claim is that we should not be unjustly enriched, which means keeping something for doing nothing. That leads me to suggest to you all that when you're taking money from your guests for future travel, if you're going to talk about the fee, the price, you can talk about it in terms of a service fee or a planning fee, so that the deposit isn't just a deposit for the trip, it may be a non-refundable planning fee. That's something that enough of us didn't do last time around, and it's come back to be a hassle. This slide is an example of us using the court to our advantage. This is a client of mine who had groups booked at a New York hotel. The hotel closed. The trip was canceled. The hotel hasn't reopened, and we didn't get our money back. So we filed a lawsuit against the hotel for keeping our money. That's using the unjust enrichment favorably, as opposed to the travelers using it against us. There's never an ending to this COVID conversation. I now need you guys to think about what you're going to do for feeling comfortable for bringing people anywhere. What's too many people? What's not enough people? What's the economies of scale about being able to run the trip if you don't have enough people? Rick Steves was talking a little bit about that, about the size of the group. It all matters because it's the economies that allow us to make money in the travel business. So what are you going to do? Are you going to require testing? Are you going to take temperatures? Are you going to have symptom checklists that go out to the traveler? Some of you don't have the luxury of knowing the traveler long enough to do a lot of this because you're just meeting them. They're signing up for your day trip. So you're in a tougher position because you don't have the luxury of a 72-hour questionnaire. And in some instances, your vendors and the companies you're working with are forcing you to do questionnaires, waivers, and testing. I just did some document drafting for a client that's doing a spring break ski trip to Colorado, and the hotel is forcing the tour operator to do pre-trip testing. I think that really places an undue burden on travel companies. My goal for you is, please don't become medical professionals. Don't become doctors. I'm not in favor of you taking temperatures of people because there's a million reasons why that's not a good idea. Let's start with the very basic precept that your thermometer may not be calibrated perfectly. These new thermometers that are green and red aren't really telling us a lot of information. We don't know what it's set at. We don't know that someone's normal temperature isn't 99. We don't know what the right or wrong temperature is. And then if you tell someone, hey, the temperature thermometer says red, well, are you giving them their money back? Did your trip even have trip protection coverage available? Is the person really even sick? So there are a lot of reasons that taking people's temperatures is a bad idea. Questionnaires. Well, that opens up another Pandora's box. If you're getting health information, you have to be mindful of HIPAA, the health information laws that govern what you do with health information. So the bottom line is you need to feel comfortable about what you're doing. So if you have the opportunity to ask people in advance about whether or not they have any symptoms, that would be perfect. I would hope not to go too much further than that, though. I'm getting to the end. These are some important parts of contracts: indemnification, force majeure, and choice of law. I already talked about choice of law a little bit. Indemnification is when you agree to cover somebody else if something happens, or you have someone cover you if something happens. Indemnification is a very important part of every contract that you can have. This is really on the B2B side of your agreement. Some people have it in their terms and conditions for travelers, but it's definitely more often found if you contract with a company you're doing business with, or a supplier, or a restaurant. So, good example, you're taking people to a restaurant for a meal. They get food poisoning. You get sued. Well, hopefully you have an indemnification provision with the restaurant that the restaurant's going to protect you for the food poisoning outbreak that clearly wasn't your fault. Now, if you knew that that restaurant has a history of food poisoning incidents, but nonetheless you went there, you probably do have liability that may extend to actually your company. So this slide will be available for you later. It's just an example of indemnification language. Force majeure, two important French words that we didn't really know much about unless you went to law school. But force majeure is when one party cannot do what you wanted them to do because of some situation, like COVID. So you might be experiencing force majeure being used by you or by somebody that you're in contract with. The important thing to remember with force majeure is just because a force majeure event has happened, that does not dictate anything about the money changing hands. So if you're a DEO, if you're signing up guests and you're unable to run your trip, you want to state whether you're giving a refund, whether you're giving a credit, whether it's dependent upon whether you can get money back. You want to put in there what's the remedy for the force majeure. The doctrine of impossibility and frustration of purpose are contractual, legal, technical things that I hope that you never bothered with, but it has to do with whether or not a company can actually run the trip they thought they could, or whether it became impossible or frustrated. I could keep going for so long, but that's all.
Jeff, and we could keep listening to you for so long as well. So thank you so much. I really appreciate you condensing that, because it's such an important topic and it's so big that you absolutely could go on for hours and hours. But I just have a couple of very quick questions, if that's okay. So just in terms of, you spoke there about having a contract with a restaurant if you're taking customers to a restaurant for a meal. Does the same apply, excuse me, if you are operating a food tour and you're saying you're taking customers to maybe 2, 3, 4, or 5 vendors, restaurants in one food tour, and you're maybe having a course or a small snack at each place? Is the best practice to get a contract with those individual vendors?
That's certainly the best. It may not be the most realistic thing for us all to do, because if we're doing, an appetizer, an entree, a dessert, we're not really going to be deep in the weeds doing contracts. But we're probably going to get a rate sheet. We're probably at a very minimum going to have an email or a piece of paper saying how much it's going to cost. And if you do nothing else, just add an indemnity paragraph to that rate sheet. And that would make me feel much better and sleep better at night.
Okay, that's a great tip, actually, to add that add that clause to just the rate sheet. Thanks for that. Another question that came up in the chat earlier from Sean is if an operator is selling an entire coach trip to a travel agent who is then reselling the tour, the contract is between the operator and the travel agent. How do the operators put a barrier of protection to ensure that the end user, the customer who goes on the tour, doesn't bring a claim against the company? Is there a way of doing that?
Again, indemnity is really the best way, and having contracts between the companies or having your terms and conditions spell out who's responsible or who's not. I think you can clearly, look, a lawyer can draft a million different things. That's something that can be drafted to protect you.
Okay, brilliant. Jeff, thank you so much. Vaughn, you've got a question?
I have a quick question, and then we can talk about maybe doing a little bit more of a detailed presentation for our members at some point. But a lot of our DEO members book their trips, they book individuals as opposed to groups. So a lot of them book these through online travel agencies like TripAdvisor and Get Your Guide and some of these other places. Well, the problem is essentially they're Get Your Guide and TripAdvisor's or Viator's client. So I guess how do you see that relate from a legal standpoint? If there's some issue, they're going to come after the DEO, not TripAdvisor in many cases. So how would someone remedy that, a problem if they had a situation, that relationship?
Well, so I guess one good example is that those online platforms where you can make your services available, many of them allow you to put your terms and conditions on there. So you can have your waiver and your disclaimer already loaded on your page with any of those platforms. You could always have someone sign something when they show up at your meeting location or your rally point. And that's not believe me, that's not the best way to have someone sign last minute. But I have plenty of clients that get their business through platforms like that. And we have found ways to protect them all.
Okay,
Brilliant.
Cool, I appreciate it.
Brilliant, thank you, Jeff. And yeah, we will absolutely be having a fuller session on this later on. Really appreciate the running through that quickly. Thank you. Alex, hi, over to you. Without further ado, we're now all legal. We're operating within the law. We've got to count our pennies and pay our tax. So this is where you come in and you can tell us how to do it properly and without getting our fingers burned. Thanks.
Okay, great. Thanks for having me. I know my topic is not, most people aren't that interested in accounting, but I am, and I'm going to talk to you about some ways that hopefully it'll save you some money and help your business to be successful, especially during this really tough year. It's a tough year for every business, especially your industry. So I don't have a lot of time, so I'm going to jump right into it. I'm going to start off with the relief package that Congress passed a while back to try and get more cash into the hands of businesses and provide some relief for all these closures. The big program that everybody has been talking about is the Payroll Protection Program. These were loans that were done. The program is actually closed. You can't get a loan anymore. But if you did receive a loan, right now is the time to be focused on getting that loan forgiven. These loans are fully forgivable if you spent the money on payroll and rent and utilities. You can get it 100% forgiven. There's certain limitations, but most loans will be forgiven 100%. The key to this is having great documentation. The IRS has already said that they're going to audit a lot of these loans. Any loan that's over $2 million will be audited. That's a guarantee. Many loans under $2 million will also be audited. So you really need to have all your paperwork in order when you get these loans forgiven. The way to get it forgiven, your bank will send you a packet with instructions. Some banks have the instructions all done already. Some banks don't. Just wait for your bank to reach out to you. They will send you something. There'll be a list of documents that you have to provide. There'll be some calculations you have to do, and you just submit the forgiveness application, and they will go ahead and process it. Now the IRS has signaled some unfavorable tax treatment for this kind of loan forgiveness. Basically, they've said it's going to be taxable income. They haven't issued official guidance yet, and Congress has said they may change it. So keep an eye out in the news for what Congress is going to do, especially now that the election's over. It may move a little quicker, hopefully. We're hoping they change the law so that this doesn't turn into income for you, and it'll be a tax-free loan forgiveness. There's another kind of loan that that was done. It's called the emergency income disaster loan program. It's a pretty good loan based on the terms. 3.7%, 3.75% interest rate over 30 years. That's pretty good. If you got one of these loans, there's a lot of things that you should probably be aware of that you may not know. The terms of the loan are actually pretty restrictive, and I don't have time to go through all of these, but I'll talk about a couple of the key ones really quick. A big one is this point about collateral. So if your loan is over $25,000, then all of your business assets are collateral for this loan. What that means is that if you go into default, the SBA can take your business assets, and they also have placed restrictions on what you can do with those assets. That includes your bank accounts, your equipment, your inventory, any business assets that you have. You cannot sell them, you cannot transfer them, you can't do really anything outside the normal course of business with your business assets unless you get prior written approval from the SBA. So what does that mean for you? If you have, say you have a bus or a truck or some kind of equipment and it's getting old and you want to get rid of it, you can't sell it until you get written approval from the SBA. So that could turn into a big deal for you. Something that you need to be aware of if you have this loan. Another big one is this: no distribution of assets. You are not allowed to distribute cash out of your business to yourself. You're not allowed to loan yourself cash. You're not allowed to give yourself a gift or a bonus or a loan without written approval from the SBA. I'll let you read through the other ones, and if you have any questions on these, feel free to reach out to me. But it's actually a pretty restrictive loan, and you need to be aware of those restrictions if you're going to hold on to that loan and not pay it back. So now I want to talk about a new rule that was made for for businesses who have losses in 2018 through 2020. This is going to include a lot of you probably. It's kind of a complicated rule, but it's really, really good for businesses that have business losses, especially businesses who have had income in previous years. So in 2017, the Republicans passed a new tax law. They overhauled everything, and they changed the rules on these net operating loss carrybacks. And what they said was you can't carry back losses anymore. You can only carry them forward. And the CARES Act reversed that for the years 2018 through 2020. A loss carryback is actually a really good way to get cash into your business now rather than waiting for a future year. So for example, say that you made $100,000 in 2018, and you made $100,000 in 2019, and then 2020 came and you lost a ton of money. Say you lost $200,000 in 2020. Under the normal tax law, you would have to hold on to that tax loss until future income comes along that you can use that loss to offset the future income. Well, with this rule, you can take that loss and carry it back to the old tax years where you made money and say, hey, I lost money this year, but I made money and I paid tax in the old years, and I want a refund right now for that tax that I paid in prior years. Quick way to get some cash into your business. It's kind of a complicated process. If you think that this applies to you, go and get a tax advisor and have them help you through it, and get the refund that you're entitled to. Another way to get some emergency cash into your business, as part of the CARES Act, they changed some of the rules on retirement account withdrawals. These are also temporary changes. They're only good, I believe, through this year. But this is a way that you can get some extra money if you need it. So there's two changes here. One is a change to 401k loans. They increased the limits of the amount that you can borrow from your 401k. You do have to pay these loans back, but you're paying them back to yourself. You do pay interest on it. But it's kind of a quick and easy way to get some cash, to borrow some cash from yourself and use it in your business or wherever you may need to use it. You're also allowed an early withdrawal of up to $100,000. And this is from not just 401ks, but also IRAs and other types of retirement plans. You can take this money out without paying the 10% penalty. It'll be either taxable income to you prorated over the next 3 years, or you can choose to pay it back and not pay tax on it. You have to pay it back over the next 3 years if you go that route. Now I'm going to kind of move on to some more general ways to think about saving money on your taxes. I'm going to start with choosing the right entity. This is actually really important. I've had a lot of clients that I've seen have just picked an entity because their friend told them that it was the best entity, or they didn't really consider it very well, and now they're kind of stuck in an entity that causes them to pay more tax than they really should be paying. So choosing the right entity is critical. I would advise you to get with a tax professional, go through all the different options, and make sure you pick the one that helps you to achieve your goals, both in terms of liability protection and also in terms of the tax treatment of your income. So there are really 5 different basic types of entity. The first one is a sole proprietorship or general partnership. These are kind of the default entity. This is if you don't formally set up an entity with your state, this is what you have. A sole proprietorship is great because it's easy to manage and operate. There's no separate tax return. You pay tax on your personal rates. The drawback is that there is unlimited personal liability. General partnership is similar. It does have a separate tax return, but it is pass-through tax, which means you pay tax on your personal tax return at personal rates. That's great. A lot of people may not know that if you and your friend start doing business together, you technically have a general partnership. You do have to file a separate partnership return, even if you don't have an entity registered with your state. 2 people doing business together does form a tax partnership. Now, if you want to limit some of your liability and still have a partnership, you can go with a limited partnership. Limited partnership has limited liability for the investors or inactive owners, and unlimited liability for the general partners or managing partners, those who are actively managing the business. It's another pass-through tax entity. You pay tax on the business income at your personal rates. That's great. It's usually the best way to be taxed. You could also go with a corporation. There are 2 kinds of corporations. The first one is a C corporation. Corporations have great protection from liability for their owners. C corporations are separate tax entities. They pay tax at the entity level at a flat 21% rate. The rate changes periodically. I know with the election that just happened, Joe Biden's tax plan bumps the rate up to 28%. So we'll see if that actually happens. Right now it's 21%. There's a potential for double taxation in these. If you want to take money out of your C corporation, you have to pay the dividend tax rate on that income, which is usually 15%. And these are complicated entities to run, and they're a little bit more expensive to maintain. Is an S corporation. Generally, most small businesses prefer to be an S corporation. They have great liability protection, but you get to use pass-through tax rates, so there's no double taxation. They do get a little complicated to run. If you're an owner-employee of an S corporation, you must be paid a reasonable compensation. That means you must run payroll, you must file payroll tax returns. It gets a little more complicated to deal with, but in a lot of cases, it can save you money overall on taxes. And then the last one is the limited liability company, the LLC, which is very common and popular now. It kind of combines the features of partnerships and corporations, and an LLC may choose how it's to be taxed. It can be taxed as a corporation or a partnership. I think I'm running out of time, so I wanted to.
You are, Alex. Very, very quickly, I'm afraid. You got 2 minutes, mate.
Yeah. So I'm gonna summarize the last 2 slides here. You got to keep good books if you want to save money on taxes. I will tell you a quick story. I just got a new client about a month ago. Wanted me to do his taxes for the last 3 years, and his books were a complete mess. And he was sitting on a $30,000 tax refund, and he had no idea because his books were a mess, and he just didn't know. If you want to maximize your tax deductions, you got to keep good books. If you don't know how to do it, get an accountant to help you, and it'll save you money in the long run to just do a good job keeping track of everything and knowing what you can deduct and what you can't.
Okay.
So that's all I've got time for. If you have any questions for me, I'm happy to answer them. Email me, call me, text me, whatever. Open to answering any questions you've got.
Brilliant. Thanks, Alex. That was really good. I mean, you're absolutely right. It's not very interesting, but it's so important. It's so important for everybody. Thank you so much. Just a quick question from the chat. Von's answered one of them, I can see. Is there double taxation on partner LLC?
No, those are pass-through taxation. You pay tax on your personal tax return only.
Okay. Brilliant. Thank you very much for that. I appreciate it. Okay, well, we're pretty much out of time. It's time to head over. I think we've got a quick break now. Let me just check my schedule. We've got a quick break, Von. Yeah, we have.
Yeah, we have a quick break. So maybe some questions we can maybe, seems like we might be able to take a couple of questions.
So there's a question here, LLC, one member. So one member LLC, you pay taxes on the, oh, that's not a question, that's a statement, sorry. Okay.
Any other questions?
Any questions for anyone before we?
For Jeff or for Alex?
Yeah, for either Jeff or Alex. No, it looks like we are.
Oh, so he wants to confirm that question. About the LLC, is it?
Yeah. So an LLC with one member, if you don't choose to be taxed as a corporation, then it's called a disregarded entity. The IRS pretends like it doesn't exist, and it's taxed like a sole proprietorship. So you report it on your individual tax return, and you pay individual taxes on it.
Thanks, Alex. Marker has a question. Do we need to pay taxes to stimulus checks received or any government subsidies we receive?
If you're talking about the $1,200 checks you received, no, those are not. Those are a tax credit. So you do not pay taxes on those. The other stimulus, like the loans, you will probably pay some tax on the PPP loan if it's forgiven, unless Congress changes the law. The EIDL loan If you got an advance, that is taxable. If you didn't get an advance, then the loan is not taxable.
Okay, this is a question for Jeff. That's about waivers. There's a food tour operator. I'm sorry, I'm losing it because another one came in. A single guide food tour operator in Louisiana. And they want to know if they need waivers. I'm assuming if they want to have waivers, can they make another state the controlling law, or does that business have to be filed in that state for them to be the controlling law?
So they can just have no controlling law. And by and large, when people want to bring a claim against someone, they do it where they are, their home state. Now, the only time that would sort of backfire would be if the Louisiana resident brought a claim in Louisiana courts. Any waiver would be invalid. However, if you still have someone sign a waiver and they're from Florida and they trip and fall as you're walking because they claimed that you took them down a street that was unsafe, you would still be protected by that waiver in Florida. So I would, if you're in Virginia or Louisiana, I think the takeaway is still have waivers, just don't have a choice of law section.
Okay. Another question for, this is for Alex. It says, as independent contractors, what is the threshold that determines whether we need to pay quarterly payments to the IRS?
It depends is the answer. You need to determine, you can use there's a safe harbor rule which you probably should use. You need to pay 110% of your last year's tax, prorated over the 4 quarters, so a quarter of that each quarter. And if you do that, then you will avoid penalties. If you got big changes in your income, if you expect your income to be less, then you should try and calculate what your tax is going to be